I have to be honest and tell you that landlord tenant projects are probably my most hated part of what I do. I generally like the construction part of landlord tenant projects, but these projects are definitely the most difficult to obtain proper liens on and obtain money for your client. A lot of time your clients don't understand that these are landlord tenant projects when they are working on them. It's not until they go bad that they start really, telling you more of the information and you realize, oh, this is a landlord tenant project. Or they really should know that it's a landlord tenant project, but they don't give you the information that you need, and they don't have the information that they need to proceed with a lien. So, a lot of times there are these outdoor malls that are popping up everywhere that are landlord tenant projects, and they're very difficult to pin down who the owners are. And sometimes, the outside perimeters of the malls do have individual owners, but the inside part of the outdoor malls are owned by one particular owner. So sometimes you think it is all one owner, and then you start researching it and trying to discover who the owners are, and it turns out that maybe, you have a leg to stand on, but you don't know until you really start researching it. So that's one big point that I would bring out, is that when you're dealing with some of these situations, you don't always know what it is until you get into researching it quite a lot. And I would say that sometimes the research is just not that readily available either. So I'm trying to get my clients to be more on the lookout and have a little bit more information when they enter into these contracts. It's easier to get the information when you're not trying to get money out of someone than it is, like I said, when they all owe you money and don't want to tell you anything. So the general rule of law for landlord-tenant projects is that their chain of contract is with the tenant. So the lien is only on the leasehold interest, and so technically it's on the removables. Your law might be different in other states, so that would definitely be something you would need to look into. Specifically, you would need to look into whether or not you have a lien on the entire property, or if you only have a lien on the removables, or if you have a lien on nothing. I will say that knowing like the property, like the property information like I do, I would say that when you go and file any kind of deed record or lien, that it doesn't really matter what it says. If you file something that's called a lien on a property, it has usually the effect on a lien, even if it's only a lien on removables. So when I go and file a lien on removables on the property, I will tell you that it usually has the effect of a real regular lien, even though it's not a normal mechanics lien. So another point to make here would be that sometimes, you get unhappy with the fact that you can't file a mechanics lien on property. But if you can file anything on the property that has the word lien in it, that it might actually help you. It's better than nothing. So look into your state laws and determine what they will allow you to file. A lien on removable is just a lien on anything that can be removed from the property. And in Texas, they're able to remove things that weren't even theirs that they inputted into the property. So as long as it was under the main contract, that could be like a washer, like a dishwasher, or a stove, or light fixtures, AC, that kind of thing. So sometimes there are some good removables to be removed but it has to be without harming the property. There is an exception to this, and that is, and I've had this happen a couple of times, if the tenant is shown to have acted as an agent for the owner or the general contractor, then the lien can actually go and attach to the owner's fee simple interest. Often the owner exercises at least some degree and control of the supervision of these projects. So, for instance, if you are doing something in a strip center, and the owner is contracted you to do the white box, but then the tenant is wanting you to finish the finish out of it, or you meaning your client. Well, you've got a contract there with the owner for at least the white box and maybe the tenant for the rest of it. So the question then becomes, what can you lien under your owner contract? At the least, you can lien what the white box was. So these landlord-tenant situations can get really sticky really quickly.